This is a lecture on dispute resolutions, mediation, and due process hearings. My name is Dr. George Giuliani from Hofstra University, and today what we're going to talk about in this brief lecture, talking about the idea of due process and basically the concept of what happens when school districts and parents don't agree when it comes to special education decisions. So, going to the first slide, what happens if parents disagree with the school district over a child's identification, evaluation, and or placement? I mean, what actually happens when we go to an eligibility meeting or a committee on special ed meeting and the parents and the school districts don't agree on the decision? What happens if the two parties can't agree on what is appropriate for a child? Well, when this occurs, no one is considered right. It's not as if we say, well, if parents and school districts agree, the school district is right, or parents and school districts agree, parents are right. What happens is that parents can initiate what we call a due process hearing, And when a due process hearing request is filed by a parent, the process of trying to resolve the issue without going to the formal due process hearing is the next step. So when the parent actually files for a hearing on the matter, what we call a due process hearing, the next step is to try to resolve this before actually going to the hearing, kind of a resolution process. And this resolution process was a step added to the due process complaint procedures in IDEA. And the idea was that with the Individuals with Disabilities Education Improvement Act, Congress recognized the need to provide additional opportunities for early dispute resolution before going to a formal due process hearing. So what this means is this. Parents and school districts disagree. Parent files a formal complaint, a due process complaint, to have a hearing on the matter. Now what happens is we try to get the school district and the parents to resolve this before having to go to a hearing, before we actually have to go through a whole legal hearing process. Maybe this can be resolved without doing it. So this resolution process was a step added to the due process complaint procedures because we want some kind of early dispute resolution before going to a more formal court hearing, a more formal due process hearing. And when you think of resolutions in special education, the resolution process, before going to a due process hearing, there are one of two things we could do. One, we could call for another IEP meeting to resolve the issue. This is called a resolution meeting. So we could say, look, let's have another IEP meeting. Let's discuss this again to see what we can do. Maybe cooler heads will prevail and we can figure out a way in which to make this right. So we call for another IEP meeting. Maybe the issue then gets resolved and then we never have to go to a due process hearing. Or the second option is to request what is called mediation. And you've probably heard of the term mediation before, but we'll discuss it in a moment. Now, one thing to note, a resolution meeting doesn't have to be held if the parents and the school district agree in writing to waive the resolution meeting or they agree to use mediation. So we don't have to call for another IEP meeting or even try to resolve this if both the school district and the parents say, you know what, this isn't right for us, we're going to go right to due process. But again, in most situations, what we have is a situation where parents file a complaint for a due process hearing on the matter, which we'll talk about a little bit later, what goes on there, and then we try to resolve the issue before going to due process. We can call for an IEP meeting, or we can request mediation. Now, what is mediation? Under IDEA, states are required to offer mediation as a voluntary resolution option for parents and school districts to resolve disputes. It's not required, but IDEA encourages mediation before going to the more formal procedure of a due process hearing. So the federal law can't mandate mediation, but it really encourages, before you go to a more formal legal hearing, why don't we try to mediate this? Why don't we see if we can mediate this and resolve the issue? And mediation is a voluntary process that may be used to resolve disputes between school systems and the parents of a child with a disability. And under IDEA, states must now establish procedures to ensure that mediation is available whenever a due process hearing is requested. So anytime a due process hearing is requested, Before we ever go to due process, IDEA encourages parents and school districts to mediate this out, okay? If you can't, work it out through an IEP meeting, at least call for a mediation, in order to resolve the issue. Now, what is mediation? What are we talking about when we talk about mediation? Mediation is a dispute resolution and a collaborative problem-solving process. So we're all going to be working together, in which a trained impartial party, who we call the mediator, a trained impartial person, facilitates a negotiation process between the parties who have reached an impasse. So mediation is really an idea or a way of resolving disputes by working together with someone who's trained, a trained impartial person, someone who has no stake in this. And that person tries to help negotiate an agreement between the school district and the parents. So the role of the mediator is to facilitate discussion, encourage an open exchange of information, assist the involved parties in understanding each other's viewpoints, and help the parties reach mutually agreeable solutions. So we try to mediate the situation. And in New York State, approximately 98% of all mediated cases result in agreement being reached between the parent and the school district. So think about that. When we go to mediation in special education, approximately 98%, 98 out of 100 times, the mediation will result in agreement between the parent and the school district. So there's a good reason why IDEA encourages mediation, because what we find is that it works. And by doing the mediation, we don't then have to go to a more formal hearing as a due process hearing. Now, a couple of things to note about mediation. First, a mediator has no legal authority to impose solutions on either party. So the mediator is not like a judge who has an authority. A mediator doesn't have any legal authority. The mediator is just working with the parties to try to come to an agreement. In a mediated session, the focus is on the negotiated resolution of the conflict rather than factual presentations, witnesses, or formal rules of evidence that you would see in a court of law. Mediation is an intervening resolution step that can be used prior to conducting a formal due process hearing. So again, with mediation, it's not like the mediator has power. There is no power in a mediator. A mediator tries to sit the two parties down and say, what can we do to make this right? What can we do to make this work? Mediator hears both sides and tries to resolve this, tries to negotiate a resolution. But we're not concerned in mediation on rules of evidence, witnesses, nothing like that. That's what we'll talk about with due process hearings, okay? Now, just so you know, discussions that occur during the mediation process have to be kept confidential. So if you have a mediation and it doesn't work out and the parents and the school district go to a due process hearing, what was discussed in mediation is confidential. The specific discussions cannot be used as evidence in any due process hearings. So you can't say at a due process hearing, you said at our mediation that you can't do that. The parties to the mediation process may be required to actually sign a confidentiality pledge prior to the beginning of the mediation. So the bottom line here is that what we have is that when parents and school districts don't agree and can't decide on what is appropriate for a particular child, parents have the right to initiate a due process complaint. Once they initiate that complaint, we try to resolve the issue through easier means, whether calling for another IEP meeting or through mediation. And mediation works. Mediation has been shown to be very, very effective. But a mediator is there to try to negotiate a deal between the two parties. A mediator does not have any power to make a decision. And ultimately, you hope through mediation that everything can be worked out and we don't have to go to the more formal proceeding of a due process hearing. But if another IEP meeting doesn't resolve the issue, if mediation doesn't resolve the issue, then we go to a due process hearing, a much more formal type of hearing where a decision will be made on the appropriateness of what's being fought about or what's being addressed by the parents and the school districts. So the next lecture, part 2, will discuss the due process hearings. This ends part 1 of the lecture. You can now go to part 2.